Adamson. Hello, welcome to You and the Law. I'm Mike Monta, your producer and host for today's program. And this being the holiday season, we're going to delve into a topic which might be helpful for anybody that is in the party and holiday spirit. We're going to be talking about OVIs, used to be called DUIs and DWIs, and drunk driving. Joining me as guests on our show tonight are defense attorney, noted and horse lover, Mr. Larry Denny, attorney here in our area. Prosecutor is Claudia Turrel from the city of Vandalia, noted also over the years, and a revered judge in our area, Honorable Thomas M. Hanna from the Kettering Municipal Court.
Good evening, Mike.
You're welcome. And now, before we get into a panel discussion, let me remind you that You and the Law is a monthly presentation produced here at the studios of the Dayton Access Television. DATV comes to you on Channel 5 and is the public access channel of Time Warner Cable Network in Dayton, Ohio. This program is also cable cast on tape delay, or digital delay. I don't think we have tapes anymore. And it usually comes to you on Channel 6, I think, on the Time Warner Network through the auspices of the Miami Valley Cable Council. And those you can see throughout the year after we have broadcast. Executive producer for the program was the originator of this show and former domestic relations judge Mike Brigner. We're sponsored by the Dayton Bar Association. We come to you also streaming live on datv.org. We are in audience participation, and you should be seeing a number on the screen. You don't see it right now, but you will. And the number is 223-5311, and we encourage you to call in with your questions about tonight's topics, because you're not going to get more expert opinions than the folks that we have here. So let me first ask our guests on tonight's program to introduce themselves and tell you a little bit about themselves, their backgrounds, and familiarity with today's topic. And we'll turn first to Kettering Judge Thomas Hanna. Good evening, Judge.
Good evening, Mike. I've been a judge in the Kettering Municipal Court for the past 15 years. Prior to that, I was a practicing attorney here in Dayton, Ohio, and did essentially trial work. So in other words, I appeared in courts in criminal matters, civil matters, domestic relations. And prior to that, I went to law school a little later than most. I got out of law school when I was 34 years of age, 1981.
When you start with 19, it sounds like a long time ago, doesn't it?
Yes, it does. Anyway, that's pretty much my background, legal background.
Great to have you here.
Thank you.
And now we turn to Ms. Claudia Turrel, who, as I announced to you before, is the prosecutor in the city of Vandalia. Nice to see you tonight.
Thank you, Mike. It's great to be here. Thank you. I have been prosecuting at the city of Vandalia for 11 years, and before that I worked part-time for the county prosecutor's office and was in private practice at the same time, so I kind of did both of those jobs. Been practicing for more years than I want to admit. I'm probably not going to tell you.
We could check the books, or they could back home. We won't bring it up again, though, if you don't want. So.
No, kidding you.
All right. Anything more that we ought to know?
Just that the entire 20 years of my practicing have been involved in a lot of OVIs, prosecuting them, and also a little bit of defense work. And so I've seen kind of both sides of that, and trial work is in private practice.
Thank you. Great to have you here.
Thank you.
And Mr. Larry Denny. Good evening, Larry.
Thank you. I went to Chase Law School in Cincinnati and graduated in '74 and began a general practice and did an awful lot of appeals. I had worked in the Sixth Circuit Court of Appeals during law school and then I did a lot of criminal work, including death penalty. But over the years, I found it more interesting to do one specific area, and my practice has been focused on DUI defense for at least 15 to 20 years now. That's all I do.
Great, thank you. Well, they call it OVI, and this now stands for operating a vehicle while impaired, doesn't it?
Yes, sir.
And we used to call it drunk driving, but now it includes drugged driving, I guess, also. So let's say you're out there you're driving your vehicle, or riding your horse or your bicycle or something like that, and you may have had more alcohol, or if you're in Colorado, maybe more marijuana than you ought to have had, and you get stopped by a member of the police department who has authority to do so. What kind of trouble could you be in that instance, and what could happen to you?
Well,
I know that's real general and everything, but
we're going to skip a couple steps here, but let's
Okay.
assume the officer in his or her mind feels that they have sufficient indicia of impairment, and they arrest the individual for OVI. One of the first things the officer is going to do after they make the arrest is to take the person back to a particular location, usually the station house, and ask the individual if they would submit to what's known as a chemical test. Most people call it a breathalyzer and know it as such.
Mm-hmm.
That's where you breathe into a tube, and the machine measures the blood alcohol content of your system. Under the law, that officer has two other options. They can ask for a urine sample, or they can have blood drawn. Obviously, those latter two, you don't get instant results, you do with the breathalyzer. If you test on the breathalyzer greater than 0.08, you're automatically subject to license suspension. It's called an administrative license suspension, or ALS. You also receive the citation with the charge for OVI.
And this can all happen right out on the road there, right?
Well, most of it will until you get to the testing part. There are portable testing devices, but the results of use of those are not admissible in court because their reliability is not of a sufficient quality that it's acceptable. However, it does give the officer, if he or she wishes to use it, a potential read on how much alcohol this person may have in their system and make a decision whether to go forward with the arrest or not. But be that as it may, you end up with an administrative license suspension. If you submit to the test, you have what's called euphemistically dead time for 15 days, where you get no driving privileges at all. That's on a first time. If you have refused the test the first time, it's 30 days. If you refuse the test the second time within 6 years, it's 90 days. If you refuse the test a third time and it's within 6 years, it's now 1 year of this dead time. In other words, a judge cannot grant you driving privileges. And that's before you even walk into court, and for what they call arraignment, which is when the judge advises the individual what they're facing in terms of potential penalties, inquires if they wish to speak with an attorney, and goes on from there. You want me to get into penalties, or you rather hold off on that?
Let's hold off and,
Okay.
and go back to where, and I want to ask Ms. Turrel, Claudia, if you don't mind. This person is stopped somehow. What, maybe just driving along, thinking of where they're going or whatever. What would be some of the reasons that a police officer, again with authority to do so, would stop somebody driving and then proceed on to an arrest?
Usually it's a marked lanes violation, swerving outside the lanes of travel, some traffic offenses, by far the most.
It gets you started. I
Yeah,
guess,
it pulls over, and then once they have observed a traffic offense and they pull the vehicle over, then as they assess the situation and talk to the driver of the vehicle, then it becomes clear to them whether or not they want to proceed with, or they suspect that the person is impaired.
What
and
would be
will
some of the
proceed
things
on.
that would make them feel they were drinking and driving, other than Mark Lane speeding or something like that?
Well, we have a lot of crashes. I mean, you know, police officers will be dispatched out to a crash because somebody has run into a post or another vehicle or run off the road into the ditch.
No, I mean,
but
just the regular driving along, they've been stopped, and
Yeah,
you said to make an assessment as to what they might be drinking and driving.
You mean once they've been stopped?
Yeah, once they've been
what's
stopped,
their
right.
analysis of the situation is just the demeanor of the driver, how they look, how they act, the smell of an alcoholic beverage on or about the person, their dishevelment of their clothing, whether their speech is slurred or very articulate, their eyes, whether they can track the police officer as he's standing there talking to them, whether they focus on him, whether they make eye contact with them. Typically, or I'm maybe forgetting one, but that's usually what they're assessing as they're standing there talking to the driver.
Or
of the vehicle.
whether beer cans in the car or
Yeah,
something.
or they fell, yeah.
And sometimes I've heard that the police officers will say they had a strong odor of breath mints.
Yes.
Is that true too, you think?
Well, a lot of people will try to mask the odor of the alcoholic beverage, and breath mints is one way they try, and smoking a cigarette is another. Frequently, the officer, the first thing he observes, if there's breath mints or the person is smoking, he'll ask them to spit it out or put the cigarette out so that he can assess it more clearly.
Okay, and then they go on to perhaps do other tests. I don't even know if they call them tests anymore. Observations of coordination, I think was.
Typically, they'll ask the driver to step out of the vehicle. If they suspect the driver's impaired at that point, they'll ask the driver to step out of the vehicle. And that
You have
way,
a right not to step out of the vehicle, you think?
you actually,
I should ask Larry that,
well,
probably.
you can ask Larry that and see what he says, because I'd be interested in hearing what he
Probably,
says.
right. Yeah. No, I think that's a frequently asked question, and one that probably doesn't come up where you'd have to ask about it. But.
Actually, it does come up when people refuse to get out of the car or refuse to roll the window down and speak to the officer. And, you know, typically it is the officer's observations and his articulation of those observations as to whether or not he can proceed further with his suspicions. Yeah. And, you know, you can get to a point where that officer will get you out of the car.
Mm-hmm. Eventually.
Yes.
Okay. Now, let me turn to Larry. We've been here 13 minutes. He hasn't said a word. Well, he told us where he's been. But so the driver, after all this happens, he's been arrested, goes to court, finds out about you or calls you up or something like that and comes in. What are some things that are you going to be thinking about? You probably don't have the reports right away in generally. So what are you looking to find out?
Well, when the officer first has his initial meeting with the client, he says, well, his eyes were this way, or he didn't have good balance, or an odor of alcohol. There'll be a lot of observations, but he's never met my client before. He doesn't know my client has a pin in his leg, or bad feet, or has balance problems from some injury. He doesn't know if he's a diabetic, or he doesn't know about my client. So I take a full medical history of my client, and what he ate that night, and does he smoke? Is he diabetic? If you're a diabetic, there is a odor that your breath sometimes gives off that is identical to alcohol. So I take a long history of my client's background. That's the first thing.
Okay. You're watching You and the Law. There we are. And we're talking about DUI tonight. We're about a quarter of the way into the program. And we would like you, the audience, to participate by calling in, and the number is 223-5311. And if, yes, there it is. And if our staff could leave that up just a little bit longer, I tend to look at telephone numbers and forget them as soon as I see them. So sometimes they have to actually be dialing the number. Do we dial anymore, or punch the numbers in, or say them, or whatever? So that's our number. We're visiting here with experts, real experts. Judge Tom Hanna from the Kettering Municipal Court, Claudia Turrel from the city of Vandalia. She's their prosecutor. And Mr. Larry Denny, renowned defense attorney in the tri-state area. I don't know if you'd go into the other states, tri-county at least, right?
I go to about 30 different courts in southern Ohio.
Well, that probably is tri-county at least, or quadra-county. So, all right, so we were talking earlier about what can happen and everything. The person's been arrested and comes to court. What the judge doesn't know anything until they get the file, probably, at the first hearing. What typically happens at that, and what should a potential defendant be looking for?
And that's a good question, Mike, because a lot of folks come in for the first time and they're just, first of all, they're nervous. They don't know exactly what's going to happen. So that's why I think it's a poignant question. The purpose of the arraignment or initial appearance is for the judge to advise the individual what you are charged with and what the potential penalties are. In an OVI case, there are mandatory minimum and potential maximum penalties. So the fine, there's a minimum and a max. The license suspension, minimum and max, and also jail time or days in a program on a first offense and a max. Second and third offense, there is no program. It's the amount of jail time minimum you have to, if you're convicted or plead guilty. Occasionally, I will get somebody who comes into court. I advise them on what they're charged with and what they're facing, and how do you wish to proceed? Or I may even, typically I ask them, do you want time to talk with an attorney? No, I want to plead. And I will tell them, if you plead, you can do that, but you're going to go to jail this morning because it's a mandatory. And I think, because as I said, they haven't been in front of a judge before, they're nervous, and the word mandatory doesn't register like it would typically register. So once they hear that, oh, I'm going to go to jail, then they think it through. But I've had other people still say, I still want to plead. As a rule of thumb, I typically will not take a plea from that person that day. I want to give them the opportunity to talk to an attorney. They don't have to do that, but I'll continue the case for a week, even if they're adamant they want to plead. Now, if they choose when they come back a week later to plead, now I've given them a reasonable amount of time to talk with an attorney. If they choose not to, that's their decision. Now we'll proceed and take the plea. But I am very hesitant to take a plea from an uncounseled individual on an OVI at their initial appearance. It's just fraught with too many pitfalls, and the person may have a valid defense. And my job as a judge is not to throw these penalties at people just for the heck of it. It's if you're guilty, then you'll get the appropriate sanctions imposed. But if you're not, then this shouldn't occur. And how do we know whether you are or aren't until it's investigated and evaluated appropriately? So that's sort of the rationale behind my thought process there.
Also, at that first appearance, if bond has not already been set, the person can have a bond placed on them, and then if some of them come right from jail, I guess.
It's rare, but they do. You're correct. Most of the people have either been released to a friend, a relative, et cetera, by the police, or they've posted bond if bond was set, so to speak. We have what's called a bond schedule so that the folks at the jail can determine what's the appropriate bond. But let's say we have somebody that comes in front of me and they're still in jail clothes or they're still in custody. I want to know, where do you live? How long have you lived there? Do you have a job? In other words, I'm looking for indicia that tells me that the potential of you reappearing in court when you're supposed to is greater. I'll also, if I need to, is check their driving record. If they have no priors, or even one, but there's a significant period of time between the last prior offense and now, I typically will give them an OR bond. It doesn't mean it's all that's a guarantee. OR means own recognizance. That means they give me their word they'll come to court when they're supposed to. As their driving record, I'm talking about OVI part of it, becomes more egregious, then the potential for bond increases significantly, because it's not, used to be the judge would set bond only to ensure the appearance of a person. Now there's a number of criteria a judge can consider, one of which is what's the potential for that person reoffending. And if you've got a history of engaging in this conduct, then I have a concern you may go back out and reoffend. Ergo, I feel that if I need to, I can impose a bond at that point in time.
Okay. And so the person would stay incarcerated until they can either get a bondsman or somebody over at home to
If that happens,
give them some.
Correct.
But the bonds aren't so high that they're not like $20,000 or anything like that. Most people can, if they've got people who know them at least, can do something.
Let me clarify that though.
Yeah.
If you have a felony OVI, you're probably looking
Right,
at about
okay.
20 to 25,000.
Yeah.
But on a case that's going to stay in municipal court, I think the highest bond I've ever set was probably about $5,000 to $7,500, and that's in 15
Yeah.
years. That's about the highest.
Yeah, but most of them are, first offenders, second offenders are in the hundreds usually, aren't they?
Most of those folks don't get, they get an OR bond.
Okay, okay. All right, you're watching You and the Law. We're talking about OVI. 223-5311 is the number for you to call. So call. There you go. I don't want to have to ask all the questions here tonight. I could, and I probably will, but would like to hear what you think out in TV land about this. You know, they have Me TV on now, where you can watch stuff from back in the 50s, but you don't want to do that. You want to watch us.
Yeah, the DUI level was 1.5 back then.
Right, or it was very high. Okay, well, let's talk more about the prosecution here of these types of things. You don't usually see these things until they've been through an arraignment and they've been set for a pretrial of some sort, and you can explain to us what that is rather than me explaining it. And you get the case file, and I guess look at it before the person either comes in or brings a defense attorney in.
That's true. I usually become familiar with the case once it's gone past arraignment. Hopefully the defendant at that point has hired an attorney or has one appointed, and then I can review that file with the defense attorney, and that is the time to do that at the pretrial. It requires the defendant to be there at the court and his attorney, and we will look at several different factors in the file, including the video, if there's a video of the stop.
There's more and more videos now, aren't there?
There are. I think most police agencies, at least that I deal with, have them equipped in their vehicles. It's a cost thing also, so some of the police departments are slower in getting them than others.
They help resolve some of the cases that were unresolvable in years past, don't you think?
Well, it certainly takes it out of the subjectivity of the officer, and you can sit and watch the video and draw your own conclusions. Sometimes I think it helps both of us. I think it's probably helpful for both of us to be able to see the demeanor of the defendant and the officer on the video.
Do you find that the officers comport more closely with what they say in their reports in the video now that we have more video?
I see Larry looking at me.
Yeah, maybe the officers from another jurisdiction.
Well, you have a lot of Ohio Patrol being
Yes.
at the crossroads of
Yes.
70 and 75.
We do.
Whereas down in Kettering, the thruway doesn't run through town there, so.
Little bits.
Okay.
Part of 75 is
675.
Moraine, and part of 675
Okay,
is
that's
Washington
right.
Township, Centerville. But
Yeah, that's right.
very little of it.
But you get a lot of different different police departments. Centerville, the sheriffs, State Highway Patrol, Marine, they all
Kettering,
come through his
right.
department. And they're all trained differently and operate with different policies.
Well, I'm sure, Larry, that you have had clients over the years who have said, I was not treated well, the stuff in that report's all wrong, blah, blah, blah. We've got to fight this tooth and nail, and then you look at the video and maybe they're right, maybe they're wrong.
Video is very helpful. First of all, it's a big job for us to get it many times. But once we get it, we get to analyze it, break it down, see if it conforms to the way that those tests, the walk and turn, one leg stand, and the HGN, horizontal gaze nystagmus, are done, if they're done correctly or not. And if the officer said your client did this and did that, we can see if he did or not. And then that really gives us a lot to go by.
One of the things that you just were talking about was the some of these tests, coordination, observation, I guess.
Right.
And how do those, and you see those in the reports that you get, how do those influence your assessment of whether you should be going to trial, filing motions, or trying to negotiate for your clients?
They are a huge factor. You have to remember that these are physical exercises that maybe none of us could do on a given day or night because of prior injuries, age, weight. Many factors would prohibit us from doing those. In addition, of course, alcohol could be the reason that we aren't doing them correctly. The officer has said or assumed that the reason they didn't do them right was by being impaired by either drugs or alcohol. So we have to evaluate the success or failure of that test by the rules of what National Highway Traffic Safety Administration says should be looked at and clued off.
Okay. Now, I know there's only 3 of them that they use now, right? Unless somebody's
Well, there
slipped
are
another one in.
many that they give,
Right.
but there are only 3 that have been tested and
Right.
shown to have a valid correlation to alcohol impairment.
Some scientific basis for
Right.
believing or their
Right.
believability. We used to actually do those here in the studio on occasion. We're not doing them tonight. Do you mind? You're certified in this yourself, so do you mind giving us a rundown of them? And then the judge can tell us about some of the ones that aren't preferred from way back when.
There are 2 physical tests that you do some activity, and one of them is a one-leg stand. You stand with your feet together and put your hands at your side, lift one foot off the ground, point your toe and leave that foot 6 inches off the ground and count out loud 1001, 1002 to 30. And don't put your foot down. If you do put it down, you pick it back up and continue. Now the officer wants to say if you didn't count all the way to 30, or you moved your hands more than 6 inches, or you did any number of little things wrong, he'll mark that off. It only takes 2 failed items on that test to fail that test. The other test that you would do would be walk an imaginary straight line, and you do 9 steps up, beginning with holding a position with one foot in front of the other, your hands at your side, walk 9 steps, heel to toe, turn by pivoting on your one foot, and walk back 9 steps without stopping, counting out loud, keeping your hands at your side. There are 104 clues that you could do wrong on that test, but if you do 2 wrong, they consider that a fail. Now, I would argue that
And you have argued.
I have argued that 2 out of 104 is a passing grade where I went to school, but in the police division, it's a fail.
Yeah.
The third test is one that they have to be trained to do and to see. It's called the horizontal gaze nystagmus test. Some people call it the jiggly eye test, but your eye, when alcohol affects your optic nerve, will cause your eye to jerk as it goes across a straight line. You won't see it through your own eyes, but as I observe your eyes when you follow a pen, then I can see it. It becomes more pronounced as you are more intoxicated earlier in that scan. And there are a certain number of seconds that they're supposed to move it back and forth. Should be equal tracking. We should have the pen 12 to 15 inches from your face, so we're not making you cross-eyed to start with. So if you get 4 clues out of 6 on that, that's by a trained observer, then you fail that. If you fail 2 of these 3 tests, the manual says that's a decision point for you to be arrested. If you don't fail 2 of the 3, unfortunately, you could still be arrested because the officer would say, well, even though he passed those tests, I saw this when he got out of the car. He did this. I smelled this. Many other additional factors that he could use to determine he would arrest you. So there are many factors to look at.
So there's a big jumble of things that can be taken into consideration then.
Yes, at discretion of the officer.
Okay. Well, fortunately, these things come into court. How many times do we see that these things have to be decided, whether they're any factor in determining the person's either guilt or punishment?
I'm sorry, may I interrupt you? I think we have a phone call.
Thank you.
Wow.
I'm going to make you a co-host here. All right, we have a phone call. I'll ask you that later.
Sure.
Caller, are you there?
I am here.
Well, I'm so happy to hear from you. Where are you from?
I'm from Mechanicsburg, Ohio. I've been watching you on streaming online, and I apologize if you might have already discussed this topic when I couldn't hear the audio, but I was wondering, is it to my benefit or disadvantage to do a breathalyzer test if getting pulled over?
Okay, well, that's an excellent question, and I think there's a couple of things that go into that, and we probably should turn this over to Larry.
Well, the law will punish you for not submitting to a requested blood, breath, or urine test if the officer asks you to do so. However, it may be better for the overall nature of your case to refuse to take a blood, breath, or urine test given your circumstances. Obviously, if you're very, very impaired and you refuse, they won't know to what degree, and you wouldn't be in the higher category, although you would have a refusal charge, which ups the penalty. But it keeps evidence away, or if you have other reasons that you don't think you should do a particular test, you're diabetic or some other physical reason, you could announce that to the officer. Generally, I don't think it's of a benefit to take a blood, breath, or urine test if you have had some to drink. Now, there will be a punishment for it, but it may assist in your case.
Well, let me ask you a question, which I think pertains to that. If you fail or you refuse the test, then you're going to get your administrative license suspension for a year, right?
On the first, yes.
Right, on the first. And you can still negotiate on your DUI if you're charged or your OVI. But if you, tell me if I'm wrong, if you later decide you wanted to plead to an OVI then that terminates the administrative license suspension. Would that be correct?
That would be correct.
So at least you'd have some negotiating room even if you,
That's right.
okay. Sometimes the host asks good questions.
That's true.
So-
That tells why that option is more viable.
Yeah. Okay. Does that answer your question? Do you have any follow-up? Are you still there? Okay. Well, thank you for your call. What was the question I was asking you, Judge, before
You think I remembered that?
you
I'm
you
way
told
past
me?
that age where I'm remembering.
Well, let me.
Sorry, Mike.
That's fine. Let me break in anyway, because I do have to talk just a bit about. We don't have sponsors here. We don't have commercials, but we are sponsored by the Dayton Bar Association, which has been in force since 1883, and provides services not only for its members, but the community also. Bill Wheeler is the director, has been for a number of years, doing a fine job over there, and some of the benefits are a lawyer referral service, which you can call at 222-6102, and if you don't know a lawyer, they can help you find one. We have a notary public service. If you want to become a notary, go down and apply and test, and you'll be notarizing people's drivers, not their driver's licenses, but I guess their titles. Everybody wants to have their title notarized. One of the important things we have is a Wills for Hero program, where members volunteer to create wills and estate documents at no charge for emergency first responders, fire, police, EMT. And we'll talk a little bit more about it later on. You're watching You and the Law. We're talking about OVI tonight with, look at this, I have to look at the paper to see who I've got here. Larry Denny, defense attorney, great defense attorney. He's competition for me for over 30 years or so. Claudia Turrel, who's a fine prosecutor up in the city of Vandalia, and Judge Hanna from the Kettering Municipal Court. Our floor director tells me we have a phone call, and we'll take that. Caller, are you there?
Hello, yes.
Welcome to You and the Law. Where are you from?
Thank you. My name is Darla. I'm calling from Silver Spring, Maryland.
Great. Are you?
And I'm watching streaming.
Okay.
And I have a question for the panel. My question is, if I were to get pulled over for DUI, do the police then have grounds to search my car? And I guess the question would be either whether, if I am arrested or even if I'm not arrested, do they have grounds to search my car if they have cause to arrest me for DUI?
And possibly file other charges?
Mm-hmm. Depending on what they find.
Okay. Go ahead.
Ma'am, in and of itself, the mere fact that you may have been stopped and subsequently arrested for OVI in the state of Ohio, they do not have grounds to search the vehicle unless if they see contraband, in other words, something that's illegal and it's in plain view when they look in the vehicle, then they can search the vehicle, at least as it relates to that contraband. Typically what an officer will do is ask the individual, may I search your vehicle? The person has a right to say no, and if they say no, absent some what we call probable cause, which is a reasonable basis for the officer to search that vehicle, then the officer cannot legally search the vehicle. If the officer does, the person says no and they search it anyway, in most instances, anything they find is not going to be admissible as evidence in a court of law. It'll be suppressed. In other words, what that means is suppression means that it's a legal term, which means that that evidence cannot be used in any case against that person as to criminal charges. Did I do a reasonable job?
However, in most all DUI arrests, they're not going to let you drive off with your ticket. They're going to take you down to the station. So they're going to go to your car to inventory it so they know that what you claim was in it was in it before they have it towed. And most departments tow the vehicle, so they're going to inventory it, and it will be an inventory search, not a normal search for evidence of a crime. So in that sense, they will search it, and they have a right to, and probably an obligation to secure your property before they leave it or have it towed.
And I agree with Larry in that respect, ma'am. There are occasions, albeit maybe not as often as the scenario Larry just described, if there's another individual in the car who's not impaired, the officer's not required to, but they may permit that person to drive the vehicle away so that the vehicle is not towed and the person doesn't incur a tow charge and a storage charge. Not often, but occasionally the stop occurs literally when the person's pulling into their driveway. They're not going to tow the vehicle from the driveway because it's on the person's property. That is not something that happens all that frequent. That's rather rare, but that's a potential instance.
But this inventory search wouldn't include looking in the trunk, the glove compartment, whatever they see, the coats lying on the seats or whatever. Do you think?
I'm going to defer to Claudia on this.
Actually, I think the inventory search is pretty thorough.
Yeah.
Because they're going to be held responsible if something is claimed to be missing from the vehicle. So yes, they will go into closed spaces, the trunk and things, for a means of inventorying what's there.
I will point out that most police departments have a policy as to inventory searches, which would include directives as to what they are to search. In other words, what they are taking inventory of. So if the officer deviates from that policy, arguably that's a basis for suppressing whatever may be found. In other words, cannot legally use it. But typically, as time has gone on, most officers have become aware that they really need to follow that policy, and they do comply with it.
They may also believe you're impaired by drugs because of the HGN has a horizontal and a vertical aspect, which would be indicative of drugs. If they feel you're under the influence of drugs, or they smell the burning scent of marijuana, or they see papers or pipes or something else, they may believe that the fruits of that crime might be there in the car and would have maybe probable cause to search the car for that.
Okay. Any other comments? These are great comments. But,
Thank you. No.
are you still there, caller? Any other follow-up on that, or does that answer your question? Okay. I guess folks hang up and just
Got another question?
listen. Yeah, I know.
Call, I'm sorry, okay.
So, thank you.
It's so rare we get calls, that's why
I know. Thank you,
I'm just
Judge.
excited.
And thank you, Darla, for that call. And we do have another phone call waiting, and pleased to have you on You and the Law. What's your question?
Thank you. How are you doing tonight?
Just great. How about yourself?
I am just fine. I had a question.
Where are you from?
I am from Cleveland, Ohio.
Oh, okay. Great. Watching the streaming, are you?
Yes, I am.
Great.
I was wondering, with all the states, legalizing marijuana, if it were to be legalized or decriminalized, how would that be tested in an instance of a DUI case? How would the officer, I guess, gain evidence to potentially make an arrest?
Okay. So let me ask the panel here. If it was decriminalized in Ohio, would they take that off of OVI, do you think? Or is it still an impairment regardless of its legalization?
It's like alcohol. It's not illegal to drink
Okay.
and drive. It may not be illegal to drink, to smoke if the law was permitting smoking marijuana. It would be whether you had such a quantity of either that would affect your ability to safely operate a motor vehicle. So it's not the per se prohibition, it's whether the amount impaired your ability.
If I may, it's a good question that you ask. Personally, I don't think if they legalized marijuana in the state of Ohio that it would have any change in the OVI law. And as Larry correctly points out, has the person ingested a sufficient amount to create impairment of that person's ability to safely operate a vehicle. But how would they test it? They would test it either by having blood drawn. I think that'd be the most appropriate way, or with urine. In other words, take a urine sample or have blood drawn. I will point out to you that the amount of marijuana in one system, and I'm not scientific, so I really don't know what these mean other than these numbers are really, really small. If in a urine sample, if you have 10 nanograms of marijuana in your system, in a urine or greater, then you're presumed to be impaired. And I don't think that 10 nanograms is of any really significant amount. If it's blood, if they draw whole blood or serum, it's equal to or greater than 2 nanograms. So there's really not, a person needs not have that much of the substance in their system under the current law to be considered or presumed to be impaired. Hope that answers the question for you.
Well, Judge, does that equate to the point, what is it, 0.08 for blood alcohol?
Actually, there's no correlation between drugs in the system versus alcohol in the system. In other words, the 0.08 and the 2 nanograms I just mentioned are really
Arbitrarily there.
they're there, and there's no connection. There's no nexus between the two, Mike. One deals with alcohol, the other deals with drugs, and the impairment that they deem occurs when that amount or greater is in one system.
Well, has the scientific community somehow determined that that amount of marijuana will make you impaired, or are there any studies on that, or is it fairly arbitrary? I mean, like Larry said before, the DUI levels started out at 15, maybe even higher than that before we were practicing.
And that was sort of an arbitrary figure, and I'm not being critical of it, but that was a number that was sort of the benchmark number, and if you tested below that, you would typically get some type of resolution less than an OVI. And then it went down to 0.10, and that was in 1984. Actually, they did it the day before St. Patrick's Day. They made it effective.
Mm-hmm.
And then you're presumed impaired, and then the federal government later on told the states make it 0.08, and the way they controlled that is they held the purse strings on the highway money, and if you didn't reduce your number to 0.08, you lost a lot of money. So the federal government coerced the states into reducing the number from 0.10 to 0.08, and that's sort of the history on that number.
There aren't any studies on marijuana and impairment in reaction time by a state to dictate what level would be their DUI level. There aren't any. There are studies about the level of marijuana and its effect on your body, but they haven't been incorporated in DUI law yet.
Okay, so let's say you're drinking in Ohio, it's 0.08. I guess everywhere it's 0.08 now, huh?
I believe so.
In the U.S.
Yes, sir.
How much do you have to drink to get to 0.08, do you think?
Larry has.
Larry, I know Larry knows the answer.
I've got a chart on my business card, but it depends on your weight. So if you were a 200-pound man and you had 4 drinks over the period of 2 hours, you would test a 0.09.
How many is that, 2?
4.
But for what type
4
of drinks?
And the drinks would be 12 ounces of beer, or 4 ounces of wine, or 1 1/4 ounces of 80 proof liquor. Now, if you go longer in time, some of that begins to drop off, but it drops off a lot slower than it goes up when you consume.
Okay.
So
Well,
it depends on your weight and the particular liquor.
Well, I guess what I'm asking is, let's assume you haven't had a big dinner to absorb all the stuff, and you're just starting fresh. You've seen Ohio State win the ball game, and you're going out to celebrate. When are you going to get to 0.08 generally? I know a 110-pound woman is going to get there faster, and a pound man's going to get there slower, but
Right.
what are we talking? 2 drinks, you think?
I think for the average person, 2 beverages
Yeah.
over an hour or 2 would be about where you should slow down. But again, it does depend on your metabolism, your weight, and things you've eaten.
Right.
But I have had clients who've had 6 or 7 and tested under. So
Well, okay, and I don't think there's going to be an answer to this, but I'm going to ask anyway. Let's say you're using marijuana, and I guess there's multiple ways to use it, from brownies to smoking and whatever. How much? Let's say you're smoking it. I hope I'm not horrifying the public here, that I would know that, but how much are you going to have to
they
one?
haven't quantified this relative to a DUI law yet.
Yeah, and if Bill Clinton, who didn't inhale, maybe
He'd
what?
be safe to drive.
Okay, all right. Caller, are you still there, or have you hung up? Okay. Those questions were a little out of the box. I didn't think anybody would know that, but what I'm trying to figure out is if you, I guess if you had drugs, pills or something, that could be sort of quantified, but some of these other things, it's kind of hard to say, isn't it?
The drug thing is becoming more important in this
Yeah.
area, because as we're aging, we're beginning to have to maybe take a medication for high blood pressure or diabetes or other things. And many of those have on the script, do not drive or do not use with any alcohol. So you may not have anything to drink, but only took 1 extra pill, and you might have a slowed reaction time and not be able to do feels right, and be impaired by drugs and in violation of the DUI law.
Let me add something. Larry's point's well taken. The drugs need not be illegal, Mike.
Right.
You could be
Right.
taking prescribed medication, but if it has the effect or the impact on you to impair your ability to operate that vehicle within what the law requires, you can be charged with an OVI even though you're taking prescribed medication and you're taking it according to the doctor's directive. It's the impact on the ability, the person's body, and the ability to safely operate the vehicle that's really the criteria.
Well, if those things are prescribed, in theory, they've told you don't drive a vehicle.
Correct. Well,
I
as
mean,
Larry said, there's
hopefully.
usually a little label on there that don't operate machinery, don't.
Heavy
include-
machinery.
Heavy machinery, thank you.
Yeah. I have a lightweight car.
Yeah. But it extends to legal medication that could be the cause of the
Okay.
impairment.
Let me get back. We only have a few minutes here. Let's talk just a moment about penalties. Let's say you're convicted of this OVI, and there's various gradations depending on whether you've had some before or not, but what sort of trouble are folks in?
Let me, if I may, as I said earlier, there are 3 areas of penalties: fine, license suspension, and jail time.
Okay.
First-time offender, $375 fine minimum, $1,075 maximum. License suspension, 6 months to 3 years in duration, and 3 days in jail or in an inpatient program, up to 6 months in jail. Second offender, the money goes up, mandatory minimum. The jail time goes up to 10 days minimum. The license suspension is now 1 to 5 years. They also lock up your vehicle and impound your plates for 90 days if you're the title owner of the vehicle, and there's a mandatory treatment. Third-time offender within 6 years, convicted. We're now increasing the monetary amount. The license suspension is 2 to 10 years in length. The jail time is 30 days to a year. The vehicle is forfeited if the agency, the police department, wants to take it. If they don't want to take it, let's say the person still owes money on the vehicle, that person can no longer register that vehicle in their name. They have to dispose of the vehicle. And they can't do it by giving it to a relative or another family member. They have to have what under the law is called an arm's length transaction. In other words, as if you'd sell to someone you didn't know. And mandatory treatment. You also, under the license suspension, the judges may, if they choose to, require you to have ignition interlock on the vehicle, and on the second and third offenses within 6 years, it's mandatory that you have what they call restricted plates. Those are those plates that look like New Mexico plates. They're mustard background
Party
with
plates.
cardinal
Yeah,
numbers or numerals on it.
Okay, all right.
So that, in a
That's
nutshell,
a
those
pretty
are-
good rundown. That should scare anybody who thinks that they can get away with this, because you generally can't. Our floor director, excuse me, I'm the producer. The floor director tells me we're down to closing time. We've run out of show here, so I really thank our fine guests who have made this program possible. Mr. Larry Denny, attorney, what did I say, Quadra County, Claudia Turrel, City Vandalia prosecutor, and the eminent Honorable Thomas M. Hanna, Kettering Municipal Court. I want to thank all the volunteers behind the scenes who have made this program possible. We've been talking about OVI. Thank our callers who have called in. Have a wonderful holiday season. And if you must drink, have somebody else drive for you, or know what your limits are. And have a good season, and be safe doing it. I've been your producer and host. I'm Mike Monta. Thank you for joining us. Good night.